Your Honor, as advocates for the accused person, we find ourselves in a predicament. The predicament being that the charge ought to disclose an offense known in law to enable the accused, or rather our client, to be able to take plea. Your Honor, the charge sheet that has been presented to us, in essence, gives the particulars of the offense as sending a number of emails to an email address, and the email address is provided as finance committee at parliament.go.ke. Your Honor, that email address was created by Parliament for purposes of members of the public, as our client Rose Njeri is, sending memorandums to the finance committee with regards to the finance bill that was being considered by the finance committee. And so, Your Honor, we are taken aback in terms of how do we respond to this charge when the email address was created specifically to be used by members of the public to send their memorandums either in support or in opposition to the bill that was then being considered at Parliament. So that, Your Honor, potentially any person who sent such an email can be the subject of such a charge. So not only is that charge open-ended, it fails in terms of the requirements as laid out in both Article 49 and 50 of our Constitution. And the information that is required to be provided in a charge under the Criminal Procedure Code. So, Your Honor, with that difficulty, we invite this court to decline to admit this charge. Your Honor, even as we invite this court to take the route of declining the charge that has been presented before you, we'll also be asking this court, because we believe that this is a matter that the court ought to reflect on and reflect on deeply, to make an order releasing our client on personal bond so that, or on extremely reasonable grounds, so that she can be able to enjoy her freedom even as the court interrogates the issues that we've raised before you. Your Honor, would also be equally asking the court to make an order that the items and gadgets that were illegally seized from her person and at her premises, being a CPU, a hard drive, a flash disks, her mobile phone, be immediately released to her. And that any information that was obtained therefore are ideally fruits of a poisoned tree, and cannot be relied upon in this trial. Finally, when you look at the nature of the offense that has been referred before you, you'd be hard-pressed to understand why the DCI would not release our client on police bond, having arrested her on a Friday and knowing very, very well that Monday would be a holiday by virtue of the fact that Jamhuri Day fell on Sunday. Madaraka, sorry. So in essence, that fact in itself points at the kind of malice and misuse of police powers. And at a time like this, the citizens look upon the judiciary to reset this power relationship that is being abused. and the judiciary speaks through its orders. It interrogates, as we request you to interrogate the charge sheet and to make a finding that that charge is defective and to the extent of its defect, our client should not be made or required to take plea. Your Honor, I will say one final thing and then I will cede the floor to one of our colleagues to just make some brief submissions. Your Honor, we are here as advocates because we have taken an oath. And that oath is to do justice without fear or favor, and the court similarly has taken such an oath. In the fullness of time, when regimes have come and gone, accountability inevitably always happens. And those of us who've been around for long have seen what has happened with a regime change, with radical surgery in the judiciary. And all those arise from the fact that at a particular moment in time, when such monstrous and atrocious events happen in this country, that the people kept quiet. And that the institutions which were required to ensure accountability did not live up to their billing. And that, Your Honor, we can assure the court and all of us who are here, members of the DPP, that that day will come. It might not be today because there is a regime in power that is enjoying police excesses and politicizing the police establishment to advance political purposes, but that moment will come. And when that moment comes, and I am glad that the society to which I belong to has taken a position, every other person will take a position. And also, as I sit down to my other colleagues, we just ask the court at the back of its mind to bear and take consideration of the fact that this is not just a process where we now say there is a plea and it has to be taken. The circumstances around that fact that inform the plea have to be taken into consideration. The context has to be taken into consideration. Because if we don't take into context the consideration, a time will come when that will be done. And at that point, everyone will be asked, at this point of great difficulty, where did you stand? Did you stand at the place of convenience, or did you stand for the rule of law?